Oh, fine.
Hello and welcome to our very first Brexit webinar. Thank you so much for everybody that is joining us. We are very aware that we are taking up your lunch break. So we are going to try as far as possible to keep this to 30 minutes. I'm going to quickly introduce you to our experts today. So we have Adrian Jones in the UK, we have Angie Didi Fiddler in Ireland, and we have Mark Byrne and Martin Kenyuk in the Isle of Man. Now, you will notice that Mark and Martin are sitting rather close to one another. The reason for that is not because we are breaching any rules, but lockdown restrictions were removed in the Isle of Man in June. So very fortunately, or not, they can sit close to one another. So today we will be discussing deal or no deal, and we're going to focus on what we do know, what preparations we can make before a decision is made. We're going to do some myth busting, and we're going to talk about timing. Please do keep your questions coming in. We've had a lot before this session started, so we're already trying to answer those. Our next two sessions, so next Tuesday on the 3rd and the following Tuesday on the 10th, we're going to go into some specifics on the various solutions that you might want to implement. So today is going to be more what we do know, what we can do, and how we can get prepared. There'll be some polls throughout today, so please do participate in those. And I'm going to launch our first one right now. So please do let us know what you're thinking and where you are in your preparations at the moment. Our focus is really going to be on VAT and customs today. So we're not going to be touching upon flying rights or cabotage rules, and we're going to try as much as possible not to get into any politics. Let us kick off. So I think it's important to start with, as much as possible, what we do actually know. So Mark, I was wondering whether you can tell me, what do we know what will happen to business aircraft after the transition period on the 31st of December?
Well, this may not be a very good start, Heather, but actually we don't really know what will happen on the 31st because there still is not an agreement between the UK and the EU. If there is an agreement to be had, I'm expecting that it will be announced, I'm guessing by the end of this week, maybe at the latest the end of next, because really, you know, the clock's running down in terms of getting this through the various parliaments. So at moments like this, I always remember what Martin Fiddler himself used to sort of say to me whenever he was introducing the subject of VAT and the EU, and that is the absolute basics. It is illegal to travel in an untaxed means of transportation in the European Union, whether that's a bicycle, a car, a train, or a plane. You have to account for VAT if you're flying around within the European Union. Now, VAT, of course, is a consumer tax. It's a tax paid by consumers and collected by businesses on behalf of the governments where they're located. Businesses are able to recover the VAT by either reclaiming it or offsetting from the VAT that they collect. And that would apply to any business tools that they have, which would include, of course, business aircraft. So that's the basic rule. Back to you, Heather.
Thank you. So I think that sets the scene. But going into a bit more detail then. So most aircraft that are flying into the UK, EU, or between those points at the moment are either using temporary admission or they might be permanently imported. Angie, can you give me a bit more detail on how both of those forms are going to be impacted after the transition period?
Yes, of course. So if we look at permanent importation, first of all, aircraft that have been imported into the EU via the UK may no longer be in free circulation in the EU and vice versa. Those imported into the UK, free circulation via the UK rather, will not be in free circulation in the EU. Now, if they wish to operate in those two jurisdictions, they are going to either have to do a re-importation into the opposite jurisdiction, or if they meet the criteria, can maybe use temporary admission. Now, the thing about temporary admission is that UK, Isle of Man, Channel Island aircraft will be able to use temporary admission in the EU, which they haven't been able to do up to now. With respect to aircraft eligible to use TA, they can continue to use that, providing they meet the criteria, we have to say that. But they will now have to deal with 2 separate jurisdictions. So for instance, if they've come in and claimed temporary admission in the UK, that does not give them TA in EU. They would need to then claim temporary admission first point of arrival in the EU following 1st of January.
Okay, so let's talk about aircraft that have been imported via an air operator's AOC. So I know we're not talking about cabotage or flying rights, but Martin, maybe you could give us some light. Is there any special considerations if you've been imported via an AOC?
So all the aircraft that we're talking about, they'll have a relationship with the EU in terms of customs and VAT. AOCs, they may have zero rate at the import, or they may have paid and reclaimed or deferred and reclaimed. But the important thing is that all aircraft that we're talking about, they're going to have their relationship with the EU, the UK changed in some way. So just because an aircraft has been imported by an AOC, it doesn't confer with any special rights. You still need to address the issues. And obviously owners are going to want to know from their AOCs what they've got in place to deal with this.
Okay, a couple of questions coming in. One of those revolves around the registration of the aircraft and whether or not aircraft that are not on a UK or a European registration are outside the rules or any special consideration. Angie, are you able to talk to me on that?
Yeah, just briefly. No, there are no special rules. Again, if the aircraft have been imported correctly into the EU, they will retain EU free circulation. If they've been imported via the UK, they'll have UK free circulation. The registration of the aircraft doesn't come into it. It's where it's basically how the importation has been dealt with at the time and making sure it was dealt with correctly.
Again, staying with you, Angie, another very popular question that we've got at the moment is, what about aircraft that were imported prior to 2011 under the old rules? So they would have come into the UK, and I think you probably dealt with most of them anyway. Do they have any special consideration?
No, no special consideration. Same thing again, if they were imported correctly under the old regulations, and you're quite right, Heather. I understand from HMRC that 70% of all aircraft that came into the UK came through our Stansted office. But same thing again, if they've still owned and operated in the way they were dealt with at the time of import, then they'll be imported into the UK, but not in the EU. We need to make sure, obviously, that nothing has changed in respect of who the importer was at the time, and make sure nothing else has changed that might have taken away that free circulation. Again, it's all stuff, take advice, review what you've got, don't ever assume it.
Great. So I'm just going to end our first polling and share that. So it is looking like the majority of people have gone for that they are totally stumped, but encouragingly, a lot of people got stuff under control. A lot of people are already looking at their paperwork, and even if they've looked at it, they're starting to think about it. So I get rid of that. So let's go into a bit more about how we can prepare. I'm just going to say at the moment we are recording this session, so if you're having any internet difficulties or connection difficulties, we will share the recording after the webinar is finished. So I'm going to ask everybody not to laugh right now. I have done some calculations, and by my calculations we have got 66 days up until the end of the transition period, and bearing in mind that 20 of those consist of weekends or bank holidays, that gives us 46 days to get ready. So we need to be able to do some preparations right now. Mark, are you able to talk me through what preparations we can do before we know that a decision is going to be made either way?
Sure, yeah. So whatever the outcome of the negotiations are, we are going to find ourselves in a situation where, you know, we have to ensure that the aircraft that are affected are appropriately configured with the new rules as they exist. In order to do that, though, we need to understand where we're at the moment. So that's going to require everybody to dust down their files and get out the paperwork that supported the current status of the aircraft as it is. So if the aircraft were imported, say from the United States into the European Union, then you need to get hold of the SAD, Signal and Administrative Document, or C88. Or alternatively, if it was bought within the European Union, you need to be getting out your invoice files or intercommunity acquisition paperwork that shows what it was that was done at the time that you acquired the aircraft and imported it into the European Union as was. That should give a good indication as to where your aircraft or what your aircraft status currently is. It's not the be all and end all. We still need to check it because some things do change over time. But that's very definitely something that we're going to need to be doing now. We need to be getting the paperwork out, making sure that we've got the right paperwork so that we can make a determination as to what the current status of the aircraft is. And from there, once we know what the outcome of the negotiations are, we'll be able to mark out a path from where we are to where we need to be.
Okay, so it's encouraging that we can start to make preparations. So given everything that you've just advised, most aircraft owners are incredibly busy people. They might not be looking at this themselves. So they're probably going to want a team, their advisors to look at this. Martin, you've got a lot of experience with working with business aircraft owner teams. Can you shed some light on what the team you would want to set up to look at this would be?
Yeah, sure. So anybody who knows you knows you're a fan of Marvel and superheroes. So it's advisors assemble for this one, which is the paperwork is going to tell you, well, who is involved in the import or the acquisition right at the very beginning. So aircraft manager, aircraft operator, the tax advisor, the lawyer, and actually the conversation with them is not only what have we got, but why have we got it? What was it that we did at the time? And why did we do it in that certain way? Because obviously the deal, the transaction would have been structured to achieve a result. And then looking at that together is, do the aims stay the same? Has things changed in the intervening period? And the future, is that going to look different? Do we need to have a different kind of angle on it? So don't go it alone, use the resources. So operators, lawyers, tax advisors need to get together to put their heads together to understand what the paperwork is saying and actually what the future needs to look like, because aims may have changed.
Thank you. So I know, because I can see the questions coming in, that quite a few people have asked, are there any specific documents that we could recommend that the teams look at to get an idea for what they're looking for? Mark mentioned earlier a C88. Adrian, you often are looking at these details for clients. Would you be able to name any specific documents that people should be looking for? And I'm going to try and share a copy of a C88 at the same time while you're giving an overview.
Yes, there are two halves to this equation, if you like. The first element is the customs status of the aircraft, whether it has been imported and is in what's known as free circulation in the EU. Now, free circulation can be because the aircraft has been manufactured in the EU, and some are, but the majority are imported, and they would be imported using something called a single administrative document, as Mark mentioned, or a SAD. In Italy, Spain, this could be referred to as a DUA. In the UK, the form is a C88. But the key point here is they're all the same format. So they're instantly recognizable in every member state. They have a number of boxes. They contain details of the importer, the consignee. They should have details of the aircraft written into them, the serial number, the registration type, etc. And those documents will tell you about the import status, the free circulation status. The other half to the equation is the VAT. So where has the VAT been accounted? Where has the VAT been paid? Now, for importations, VAT is typically declared and perhaps paid at the time of import using the import document. But as Mark mentioned, it might be that you have an invoice plus VAT, in which case that is your proof of VAT status. It may be that you've purchased on an intra-community basis between 2 EU countries, in which case your accounting records at the buyer's end of the transaction, those are the records that will show that VAT has been properly accounted for. So it's best to try and secure an overall understanding of the fiscal status of the aircraft by marrying the VAT and customs elements together, considering the documents and looking at the overall position.
Okay, we've touched upon timing. And Adrian, I'm just going to stick with you. So going back to my calculations again here, we are expecting, or at least we were told, that we were going to get a decision on whether there'll be a deal or no deal by the 31st of October. So by the time we get that decision, there'll be 42 days left. So we've just learned about how to prepare ourselves to get ready to make a decision. And over the next 2 weeks, we'll be talking about solutions that you might want to implement. But on timing, are aircraft owners able to decide on a particular solution before the end of the transition period?
Well, there are two things to say here. Firstly, if you're looking at separating the two customs areas and somehow re-importing aircraft into the other area, then that's a problem right now because you can only be imported once. So we have one customs territory, and if you're imported, that covers everything. So it's not possible to carry out a correction, if you like, in most cases before the end of the year, when you end up with two separate customs territories, and then you can look to bring the aircraft back into the other one that you may need to.
Okay, so just going a bit more in this subject, the various solutions will have various times that it will take. Can you tell me about lead-in times and how people can best prepare themselves for the amount of time it might take to implement a solution?
Well, there could be three broad categories of solution, if you like. Ultimately, the detail might be more complicated than this, but at the simplest end, you have temporary admission. So if you need to get back into, say, the remainder Europe from the UK, you might simply be able to arrive under temporary admission. There's no lead-up time for that because it's an automatic permission. There's nothing to pay, you simply arrive, and if you meet the conditions, then you enter under temporary admission. It's good to get advice on what those rules are so you don't break the rules, but apart from that, there's no real lead-up time. The second category is re-importation. If you want to be re-imported into one or the other territories, then typically that needs a few days, a few working days, to make sure that the details are prepared correctly by the import agent, that they are pre-lodged perhaps with local customs before the aircraft arrives. So some planning there. And you might want to think about what VAT you're paying at import and how any VAT efficiencies can be applied at that time. The longest lead time is where you might need to restructure. You might need to put a new company in place. And that could require several weeks because you put a company together, you transfer legal title perhaps, or you would, and then you would re-import the aircraft subsequent to sorting out perhaps a VAT registration. So if that is the plan of action, and I would recommend an early assessment of what might be needed, because if that is your plan of action, you really need to act now, start now.
Okay, thank you. Thank you very much, Adrian. I'm going to go and launch our second poll. So please do participate and let us know whether we're helping you at this point in time. I want to talk about certain myth busting. So things that have been spoken about throughout Brexit leading up to the transition period, some which are slightly fantastical, some which are wishful thinking, and some are more likely to happen than others. Now, one of the questions that we've had repeatedly, and Martin, I know it is your pet favourite subject, will it matter where the aircraft is positioned on the 31st of December?
So, okay, so I want to send a note of caution to everybody, because it is one that keeps cropping up, and I have to talk to people about it, is that at the moment, aircraft, if they're tied to, let's say, the UK, if they're tied to the EU, they'll fly out of those jurisdictions, they'll spend time away, and when they come back, they haven't lost their VAT and customs status, because they can avail themselves of return goods relief, which is RGR. It's an automatic condition. So you come the new year, that is still going to be available. It's not like that is going to be lost. However, it will apply to one jurisdiction or the other, where you consider your home base is. But what I've heard is, say, people in the UK being told that actually what they need to do is to get their aircraft into Europe, so that on the 31st of December it's sitting on the ground in Europe, and therefore it will achieve an automatic status in Europe. Now, that might be true for that overnight period, or for the time that it is then inside the EU. However, aircraft are mobile, as we know, so at some point it's going to leave the EU, maybe go to the UK or maybe further afield. And what I would caution against is trying to rely on the fact that because it was on the ground in the EU on the 31st of December, it's gained a right that endures, because that leaving the EU will have broken the chain. So I would be very, very cautious about thinking that because you were overnight on the 31st of December in one or the other, that you've gained an enduring right to be imported. I think that's kind of come about through goods that would be put into the EU or into the UK and then not leave again. But obviously aircraft, that's not the case. They are going to move.
Thank you. So going on to another popular myth, wishful thinking, fantasy, and maybe I should be politically correct and call it grandparenting, but let's talk about grandfathering. Adrian, my understanding of grandfathering is effectively what was before will be in the future. Maybe you can possibly give a better technical explanation of that, and also what is the likelihood of grandfathering actually happening?
Okay. Grandfathering is where, after separation, the aircraft that find themselves the EU side of the dividing line are accepted into the UK as they were before, in free circulation in the UK. Also the other way round. So aircraft that find themselves primarily based in the UK, fiscally centred in the UK, are also accepted into free circulation into the remainder EU. So this provides continuity for aircraft. Now, I know that from talking to some negotiators who are having discussions with the EU, that if they get to discuss everything, and if there is an agreement, then aircraft will be special cases. They will be given special consideration. I don't know what that special consideration might be, but there are two big ifs there. So is there going to be an agreement? Will they have a chance to discuss everything? It's unlikely. I think current negotiations are going to be around key issues such as tariffs, quotas, and the bigger trade picture. I think right now there is a fading hope that there will be any kind of grandfathering. I referred to it earlier as a bit of a unicorn in this whole scenario. And I think we need to plan for reimportation or correction of any fiscal status after the separation as needed.
Thank you, Adrian. I'm very conscious of time and everybody's lunch breaks. So we've got another very popular question. And Angie, maybe you can answer it. So what about aircraft that are going to be purchased after the transition period? Is there any special consideration for them? What might happen?
No special consideration. They'll be far easier to deal with than the current aircraft, for want of a better expression. New aircraft being delivered after 2020 will need to be imported. If they're UK based, they'll need to be imported into the UK. If they're EU based, they'll need to be imported into the EU. And then depending on the operation of the aircraft, they may need to be imported in the other jurisdiction as well. So the easiest way, and I've been explaining it to people previously, is think of the UK as being like Switzerland. So a Swiss aircraft, be it owned, registered, etc., being based in Switzerland, needs to be imported into Switzerland and will account for tax there. Then it also needs to import into the EU to get EU free circulation. So the UK will be exactly the same, as I said, as Switzerland. We're outside of the EU. We'll have to deal with both EU and UK taxes if that's the intention to operate, and clearly in nearly every instance it will be. And likewise, EU aircraft, if they need to come into the UK, may need to either be imported or use temporary admission. Again, it depends on the actual operation of the aircraft.
Thank you. Right, I'm very conscious of time here. I'm going to close the polling in just a moment, but if I can summarize, and my colleagues tell me if I've got this wrong. So when we're looking at aircraft moving into, between, within, in or out of the UK and the EU, we can basically say that all of them are going to be impacted in one way or another. They are going to have to make a decision when moving between. We do know that we can get prepared. We know that there are documents that we need to look at, and we need to get the right team. The timing is really quite important, because we need to get ourselves prepared, and then we need to decide what solutions might be available and have sufficient lead-in time. We know that there are certain unicorns that would be lovely to have, but maybe aren't realistic, and we can't count on. We will be sharing a copy of the C88 together with the recording of this webinar later this afternoon. I'm just going to close the poll now, and it would look like we have been successful in making you less lost when it comes to getting prepared for Brexit. So I would say that's a success. Thank you very much for participating today. We really hope you will join us over the next 2 weeks. So we're having another one at the same time next week, which will be your business jet blueprint for Brexit. Try saying that in a rush, it's not easy. We would like you to carry on asking us questions. If we haven't answered a question that you would like to answer, and that we have had quite a few of them in, please get in contact with us. Our contact details are on our website, martinfiddler.aero. You can contact me on the invitation that I've sent you, or contact us via LinkedIn. Thank you very much. A special shout out, my dad is watching today, so that's no pressure on my side. Please keep well, stay safe, and we look forward to seeing you next week. Thank you.